Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, where we're going to be discussing the right to know law, but in the context of law enforcement. A couple preliminaries before we get started here. First offhand, this session is being recorded. And if you would like a copy of that recording within a couple days, it's posted to YouTube, and then a link to that YouTube, to our YouTube channel, is posted on the website. So you can go to the Office of Open Records website, openrecords.pa.gov, and get a link to this. It may prove useful to you for future reference, or maybe you have a colleague who couldn't attend this morning and you can use that. You can also use it for local training, whatever you want. I mean, you know, it is a public record, so you have access to it. Also, if you've never attended one of these sessions, it's basically a PowerPoint presentation with me talking in the background. The PowerPoint, as well as all of the PowerPoints that we use for our training, are also on the Open Records website. Go to the training tab and you can find it without much trouble there. Again, public record. You're welcome to use it for future reference. Maybe that colleague that couldn't make it this morning, or if you want to conduct local training and use our PowerPoint as one of the tools, you're more than welcome to do that. Now, I mentioned that I'm talking in the background during this, so if you have questions, what we can do is you type in the chat feature, and I will do my best to answer your questions as we're going through the presentation live. Two conditions, though. First is that, you know, we're talking about right to know law for law enforcement, so let's stay on topic with that. The second is that if you can keep your questions as succinct and brief as possible, it makes our life easier. What happens is occasionally people will type in a paragraph or so, and honestly, it's just awkward for me to sit here and have to read through it, have that silence while everyone else is waiting patiently. If you have something that's unusually complex or specific to your organization, we'll do one of two things. We will wait until the end of the presentation, and I'll come back to it and address it for the good of the order, or we'll take the conversation offline, where you know, the phone number and website address are on the screen right now. You can reach out through those means, and you'll be put first in touch with administrative staff here who are very well versed in the law. And if you happen to stump them, they'll escalate it up to one of senior management. And usually what happens is we get back to you within a day. We do our best to do that because we figure, you know, if you're contacting us, it's something time sensitive and it's something important. So we want to make sure that we get you headed in the right direction there and can solve whatever problem you have. You know, we can't answer requests for you. We can't speak to active appeals, but a lot of times there is a precedent with many of the decisions that we've already issued where we can point you to how we ruled in a similar factual situation, and hopefully you can glean from that the appropriate course of action to take. Okay, I think that's everything that we have. Are our speakers still supposed to be off? Okay, I'm not sure what that means. If you can, hopefully you're hearing my voice. Your microphone should be off, as well as video, that those are turned off. I'm really not sure what you mean there with the, hopefully you can hear my voice. If you're having trouble hearing my voice, and you're not hearing this anyway, the solution usually is to log off and log back on. Let me type that in real quick. Well, no, we gotta move on here. Bear with me here, folks. Okay, so let's proceed and get back over to this screen and talk about the right to know as it applies to law enforcement. I think it's important to spend a little bit of time talking about why the right to know law is important. One of the reasons that we have this particular webinar is that we realize that law enforcement has enough on their plate where while they have to be aware of the right to know law, there are some, you can't be experts with everything. So for the purposes of law enforcement, what we're going to do here this morning is focus on those components of the right to know law that you should be aware of, both so that you can provide adequate service in response to right to know requests, as well as be aware of the protections that are built into the right to know law to ensure that you're not releasing any confidential information that you otherwise should not be. Okay, so that's why we address specifically law enforcement here this morning. But as far as the right to know law overall, it's been around now for 13 years. So, I think we've gone beyond the point where it's a new law. We're in that maturity phase. I think we're still looking at court decisions and case law evolving as new technologies, new situations come out. But the premise of the right to know law remains strong, and it's a foundational statement. The purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, no more, no less. And I say no more because people see, there's a common misunderstanding where people see that term right to know, and they think that it is some form of Google for state and local government, and that's just not the case. We still see requests where someone will write out a bunch of questions, and there's the expectation on both sides of the equation that it's government's job to go around and find the answers to these questions. And that's not the case. Now, there may be instances where, yes, government is obligated to address a question through the provision of a record. But you need to go back to this premise because if you find yourself getting off track or you're confused by a right to know law request, or let's just say the situation has gotten muddled for whatever reason, go back to this fundamental statement and you realize from the government's perspective, it's our job to provide records in response to a request. And that's it, okay? And then you go through this exercise. Do we have the records, and are the records public? And that's pretty much what we're going to be talking about here this morning in the context of a police department or other law enforcement agency. So with granting the public access to public records, there are some fundamental questions that need to be answered. And also, some other premises associated with the right to know law. First premise is that every record of an agency is presumed to be public. Essentially, that's your starting point. Now, don't be alarmed by that. People will hear that. They'll get their first right to know request and they'll start researching the law, or they'll, hear about the right to know law itself, and they'll see this and they'll think, oh my gosh, everything in the office is going to end up on the front page of the paper tomorrow morning, or on, heaven forbid, on somebody's Facebook page. And I'm here to tell you that's not the case. There are a number of protections built into the right to know law, which we're going to be discussing this morning, as well as other laws that, if you get a right to know request for a record and your antenna go up and you think, I just don't really feel comfortable with the idea of releasing this record, this information into the public domain, there is a very good chance, particularly for law enforcement, that there is some protection available that will allow you to withhold it. And that kind of brings us to the second premise, where agencies bear the burden of proving that a record is not public. Okay, so our first premise is it's a public record unless agencies can prove legally and factually that the record is not public. Okay, so what does it take to meet this burden of proof as far as the agencies are concerned. And that's another thing that we're going to be talking about here this morning. How do you meet that burden of proof? And we're going to walk through that. Okay, question has popped up here real quick. Should the police department have their own right to know officer or just one person for the municipality and the police? Okay, Kim, you're getting a little bit ahead of me, but why not? Let's go ahead and answer that question now, because for law enforcement, I've had some discussions about this, and I think it's kind of unique. There is no requirement in the right to know law that you have X number of right to know officers. You can have one that covers the entire municipality, the administrative side as well as law enforcement, and there's absolutely nothing wrong with that. You can go 3 miles down the road to the next borough, let's say, and they would have one right to know officer for the administrative side and a second right to know officer for the law enforcement side. And that's okay too. However, it begs the question, and this comes up when we apply CREA, which we're going to be talking about here later in the presentation, the Criminal History Records Information Act, which mandates that records that fall within the universe of law enforcement cannot be released outside of that universe. Now, technically, you could argue that a right to know officer who is not part of the police department is outside of that universe and should not be inspecting those records. Okay. Now, this has never been, to my knowledge, litigated or brought before a court of law. And I'm not in a position to tell you one way or the other. I've had multiple discussions with police chiefs on this, and I haven't advised them either way. I've just said this is an interesting issue that you may want to discuss with your solicitor. And Kim, that's what I would recommend in your case, that if you have concerns about whether your department should have their own designated right to know officer in addition to a right to know officer for your jurisdiction, discuss it with your solicitor, discuss it with the elected officials, and make a determination as to what you think is the best direction to take. Okay, if I were a police chief, I'm not sure which way I would go. It's going to depend on the resources that you have available and the relationship that you have with your elected officials. So let's just take it from there. And like I said, I think the first thing I would do is have that discussion with your solicitor to see what's the best course of action for your particular situation. Okay, like I said, you got a little bit ahead of me, but I think it's a very good question that is very germane to this topic here this morning. Okay, so let's move on and talk about your obligations as an agency that's subject to the right to know law. And kind of what Kim was alluding to here, the most important thing you need to do is appoint an agency open records officer, or what's also known as a right to know officer. Open records, right to know, both terms are interchangeable. We call these folks AROs, agency open records officers. So from the agency's perspective, you must post contact information for your ARO, both within the physical confines of your offices as well as on your websites, if your jurisdiction has a website. You have to have a form available, both physical form in the office as well as an electronic form on your website if you have a website, so that a person who wants to file a right to know request, if they don't have that form, they can get one from you to do so. Also, many agencies will have their own forms, which is fine, but there's also the state form, which is on the Open Records website. If someone comes in with that state form, you must accept it, okay? That's built into the law. You have to have the applicable appeals information posted, which in most cases is going to be you submit your appeal to the Pennsylvania Office of Open Records. However, law enforcement has an exception, and we're going to be talking about that with one of the slides that we have here coming up, so that you need to be aware of that there is an exception for law enforcement when it comes to how a person may pursue an appeal. Then you need to instruct all your staff that if they receive a right to know request, they need to forward it to the ARRO as soon as possible. Okay, they cannot let a right to know request sit around thinking, okay, well, I'm going to see the ARRO next week, I'll give it to them then. Put a system in place so that the ARRO gets the right to know request as soon as possible, because you don't want to run the risk of abrogating your rights because there was a delay in the right to know officer getting the request. There are hard deadlines built into this law, okay? No wiggle room. And you don't want to have the clock start ticking before the ARRO has the opportunity to actually start working on the request. And you know, there are exceptions and exceptions to exceptions, of course, but the rule of thumb is get it to the ARRO as soon as possible so that they can begin working on it within the deadlines that are built into the law. And then finally, we request here at the Office of Open Records, let us know who your ARROs are. On our website, when you start surfing around, you're going to find we have an ARRO database, so that anyone coming into our website can look up through search terms, whether it be your municipality, your names, or whatever, you know, who is the ARRO for this particular municipality. And if you let us know who your ARRO is, then we can populate your municipality with the appropriate fields. We realize, you know, people move on, they get promoted, they get retired, they move to another department, whatever. So while this is a voluntary system, it's important that we keep it up to date. Also, if an appeal is filed with our office, the ARRO is the person we reach out to. Okay, so again, it's important that this information be kept up to date. Check out the website, make sure it is up to date. If not, there's a form there that you can complete with the new information. Email it to us, we verify it, we update the database, and everything's good to go. Okay, what can't you do in the context of the right to know law? Well, the first thing is that you can't compel a person, you cannot limit the number of right to know requests or records that a person requests within a specific time frame. You can't say, ma'am, I'm sorry, you've already filed 3 requests this week, that's all we're going to allow. You know, if she's inclined to file a dozen right to know requests in a week's time, the right to know law allows that. Now, let me go off script here a little bit and say that, you know, the greater majority of right to know requests are legitimate. They're filed by people who are legitimately seeking public records, and they're willing to pay a nominal fee in order to do that. And yes, we're going to be discussing fees. But we also acknowledge that there are a handful of people out there where the relationship between the department and that person has broken down. You know, maybe they got a parking ticket that they didn't agree with. Maybe they just don't like the police chief or whatever. You know, maybe they don't like the municipality, and they just, there's bad blood there. So they've decided they're going to weaponize the right to know law. They're going to be a pain in the neck, and the right to know law is one of the ways that they're going to be a pain in the neck. So they file a lot of frivolous requests. We call them problem requesters, frequent flyers, and a couple other names that I can't say in mixed company. But what we've determined, or, you know, our experience is that while legitimate requesters are willing to pay a nominal fee for public records, usually problem requesters are not willing to pay any money to be a pain in the neck. If you happen to be facing this sort of situation, what I would recommend is attend one of our webinars that's focused on the right to know law and payment issues, where we get into this in a little more detail. Okay, so I think you can see where we're headed here. I don't want to spend any more time on it, but yeah, you want to take a look and attend that webinar, or just reach out to our office and we'll try and help you through one of these situations. And if you happen to be from the public here this morning and you are one of those problem requesters, shame on you, okay? So getting back to what you can't do, the second one is that you cannot require a person to tell you why they are filing a right to know request. Okay, you cannot compel a person to tell you the reason for a request. You can't deny a request based on the reason or what you think that reason is. And that reason could be that the person just wants to see you work harder. Okay, like I said, there are solutions to these situations. And attend that webinar, or if you have questions, reach out to our office. Okay, I like to describe the right to know process as an obstacle course. And if you've ever sat through the basics course, you'll know what I'm talking about. All right, another question has popped up here. We have had 3 requests for our police policies from the same married couple. We have sent all policies, but the ones that need to be redacted have been redacted. The third right to know request has asked for all policies unredacted. At what point do you deny the subsequent requests? Okay, Mr. Frank, there is actually, and I hope it's Mr., there is actually a part of the right to know law dealing with, oh, I forget the exact term, but it's based on, disruptive requests. And a person is allowed to ask for the same record on 3 separate occasions. After the third time, and provided the agency has provided these, you can deny the request. However, the agency, and this is where it gets difficult, the agency has to solve 2 tests. The first is that the person has requested the same record 3 times. The second is that the requests are unduly burdensome. And that's the hard part. And I don't want to give you any false sense of hope here because to my knowledge, this has never successfully been applied where an appeals officer agreed with the agency that it was unduly burdensome. My suggestion at this point would be go ahead and answer the request, but if you believe the redaction is appropriate, then you just continue to redact. Maybe save the responses from the previous time and just send them the same response. A redaction, in essence, is a denial, which can be appealed, and they have been. But if the person doesn't bother to appeal the redaction, then, that's the end of the story. They have the right to appeal, but if they choose not to, they really have no subsequent course of action. And as far as you're concerned, the issue is closed. Okay, but yeah, another good question there. And I have not dealt with the whole disruptive request issue from a legal issue in some time. Pursuit policy, active shooter policies have been redacted per the solicitor's review. Yeah, I mean, that makes sense. And like I said, if they want to appeal the redactions, they have the legal right to do so. There is great variety across the Commonwealth as to how police departments deal with the confidentiality of their policies. For instance, the city of Philadelphia posts their policies on their websites, I believe, unredacted, where there are other departments that believe that by releasing the complete unredacted policy, they would be putting the public in harm's way because then criminals or would-be criminals would know at what point the police department backs off or how they respond to active shooter situations, et cetera, et cetera. So they've decided we're not going to post stuff like this and we're not going to release it. But I think, again, relying on your solicitor's guidance is the best way to proceed. So I'm glad to see that, you're discerning what should be redacted and what should not be redacted per your solicitor's review. I think that's a wise policy to continue. And I would recommend that for anyone attending here today from the law enforcement community. Rely on your solicitor's advice as to what you consider confidential versus what you could release to the public. Okay, back to the obstacle course. All right, well, you've got to start, when the gun is fired. and that is when you receive a request. Like many competitive events, there's a time standard. So we look at the deadlines. We're going to be talking about the deadlines. Then this obstacle course has 2 hurdles. And in front of the second hurdle, there are 3 hoops that you have to go through. All right. And then and only then, once you make it over the second hurdle, are you saying this is a public record and we're going to be releasing it into the public domain. So let's talk about the deadlines. When you receive a right to know request, you have 5 of your business days to provide an initial response. Now, police departments, for the most part, are 24/7 operations, but a business day would be considered when you are open for receiving the public for administrative issues. Typically, it's Monday through Friday. Now, if the administrative office is closed for a holiday, that's not a business day. If it's closed for a weather emergency, that's not a business day. So if you receive a right to know request today, theoretically tomorrow would be your first business day. Then you have extensions. Let's say you cannot provide a response, a final response within the 5 business days. You are allowed to unilaterally invoke a 30 calendar day extension. Now, a calendar day is just that. That includes Saturdays and Sundays. It includes holidays. It includes those weather emergencies. You just look at the calendar, count out 30 days, and at the end of close of business, the 30th day, that's your deadline. However, in order for the extension to be valid, there are some conditions that need to be met. First is it needs to be invoked within the initial 5 business day window. You can't wait until what would be the 6th business day, say, oh my gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, you've denied the request by default when you missed the deadline. Legally, it's what we call a deemed denial. Okay, the second condition is that you have to notify the requester in writing that you're taking the extension. And, if they submitted it by email, you can respond back by email that you're taking the extension. You need to provide a reason. And if you go to Section 902 of the law, Section 902B, it actually lists 6 reasons that you can use. We keep these records off-site. It's going to take us longer than 5 days to go find them. Or we want our solicitor to review the records to make sure we don't give out anything we're not supposed to. And it's going to take longer than 5 days to do that, okay? So you've got the 5 business days, and then you tack on the 30 calendar days. So you've got this like 35-day window that you can use. However, don't get into the habit of automatically invoking the extension if you don't need to. There are some records that are, just inherently public and readily available. So if you can get the response out within 5 business days, please do so, okay? Because nothing upsets people more than they submit a right to know request for something that's obviously a public record and should be readily available. And their first communication back from the agency is that, oh, we're taking a 30-day extension. That upsets people. If you don't need to do it, don't do it. But by the same token, I recognize many departments, you don't have a lot of bench strength, and this is the best you can do. Okay. And then the other deadline you need to be concerned about is that if you deny a right to know request, the person has a 15-day appeal window from the date of the denial. Okay, so these are the time standards. These are the deadlines that are built into the law. Again, there are always exceptions, but for the most part, you need to be aware that these are hard deadlines, okay? There's no wiggle room here. You can't ask for an extension on many of these and expect to get it. Although once you get into the appeal phase, there are some extensions, but that, you're primarily at that point dealing with your solicitor at this point and not your open records officer. Okay, let's move on. All right, we're on the obstacle course and we come up to the first hurdle. To get over this hurdle, we have to answer the question, is this a public, or I'm sorry, is this a record? Not a public record. Is this a record? Now, when you're trying to understand any law, my recommendation to anyone is always go to the definition section, because as you're reading through a law, you're going to find language that's vague, language that's often confusing, or it's conflicting with another section. And it's like you're trying to figure out, okay, what's this law mean? What's it trying to say? A lot of times you'll find the solution in the definition section of the law. And the right to know law is no different. We go to the definition section. Sure enough, there's a definition of what is a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase highlighted here. Documents a transaction or activity of an agency. All right, well, what does that mean? Let's translate this in English. Basically, a record is anything that discusses the mission or purpose or activity of our police department. All right, well, no duh, right? Why wouldn't you do that? Well, think about it. All day long, we generate communications that may not rise to the definition of a record. For instance, I understand, let's say I send a text message to one of my fellow officers. I understand that a new restaurant's opened up downtown. You want to meet for lunch tomorrow. Or let's say, what do you think about these trades that the Eagles are making? How does it look for their season this fall? Or I'm bringing home a gallon of milk from work tonight. Okay, all common communications that have nothing to do with the running of our police department. Okay, because of that, they are not considered records. So if a right to know request were received for my text messages, I don't have to worry about those particular examples being released through the process because they're not considered responsive records. They don't meet the definition of a record in the right to know law. They're off the course. They don't make it over the hurdle, okay, because they are not records. All right, everybody understand that. Now, the next thing that I need to clarify, though, is that there is nothing that distinguishes whether it's a record or not based on how that message is sent. If I'm using a department-issued cell phone to text my coworker, it makes no difference as to whether it is my personal cell phone. It is not how the message is sent, how it's generated, how it's created, or how it's stored. It is the content of the message that determines whether or not it's a record or subsequently a public record. So the point that I want to get across here is that if you're using your personal devices or personal accounts for business purposes, there's nothing wrong with that. There's nothing illegal by doing that. It's just that pardon me, there is no expectation of privacy as a result of that. So if you're using, say, your cell phone to text coworkers about department business, the messages on that cell phone are subject to discernment as to whether or not they're public records, and that you would be obligated to provide all responsive records to the agency open records officer so that they can determine what's public and what's not. Okay. There was a very early court case back in 2010 regarding this, where essentially the court said you cannot use private devices and private accounts to hide the public's business. All right, just so everyone's aware of that. There's nothing illegal about doing it. It's just that there's no expectation of privacy, even though it's a privately owned device or a privately controlled account. Okay, so moving on. The other part of that definition, any information regardless of its physical form or character. So yeah, we're talking about pieces of paper, We're talking about electronic records, emails, phone records, text messages, and the like. What about records that have been deleted? Okay, because this comes up pretty often. Well, it's going to depend whether or not it truly is deleted. Now, emails, let's use that as an example. I get an email, I delete it. Okay, well, it's gone from my inbox, but then I go to a deleted items folder. It's still there. I'm still in possession of it. So it's accessible. All right, well, every now and then I go in and I delete my deleted items folder. Okay, but then I go to a thing called a recycling bin on my computer. And yeah, it's still there. Okay, I still have it. I'm in possession. Therefore, it's still on the table. It's still on the course. It's accessible. All right, so I would need to provide that deleted message. Okay, so then we have here at the office an email server, which is like a central large computer that controls our entire email system. So I empty my recycle bin. That message now is no longer on my computer. I don't have access to it, but sure enough, it's still on the email server. My organization does. And we have IT staff, information technology people, who know how to get into that server and retrieve deleted messages. So yes, our organization still has access to that deleted message. We're in possession. It's still on the table. But wait, every so often, our IT staff needs to come in and make space on the hard drive because it's getting full. So they delete the messages from the hard drive. At that point, we no longer have possession of the message. It's gone. But you're thinking, now, wait a minute. We have forensic people in our department who can go into a computer and retrieve messages that have been deleted. Okay. You don't have to do that. Okay. There is no requirement for forensic expertise, whether it be inside the department or outside the department, to come in and retrieve otherwise deleted messages. And let's say you have an email server, but you've got a contractor that controls it, and it would cost you money for someone from outside the department or outside the organization to come in and retrieve the deleted messages. You do not have to do that in response to a right to know request. It's only internal resources and internal staff that you would be required to use in order to retrieve otherwise deleted messages. Same way with phone messages if you're using cell phones. Most cell phone companies will require a subpoena in order to retrieve deleted messages. And under the right to know law, you're not required to obtain subpoenas for phone messages. You are required to at least reach out to the cell phone provider and ask. And then their response is going to be, sure, get a subpoena. And that's where it ends, because you've met your obligation to conduct what's called a good faith search just by reaching out to the cell phone provider. Okay. The rest of this stuff, let's talk about security camera footage, because that's going to bring us into what's called Act 22, which is another law other than the right to know law. But let me talk about it briefly. There may be instances where video footage is subject to release under the right to know law. Security cameras is a good example, but Act 22 throws a wrench in this. Act 22 was passed after the right to know law to control public access to video footage captured by body cams, dash cams, and security cameras. So let's say that your police department is in the same building as the administrative side of your municipality. There is a security camera that points out to the front parking lot. What we need to determine is who is in control of that camera. If the monitor and the recording equipment is on the police side, Act 22 applies. If the recording equipment and the monitor is on the administrative side, the non-law enforcement side, then it's right to know. Okay, same camera, same view, but it depends on who's in control of the camera. Police department, Act 22. Non-police department, right to know. Okay, and next slide, we're going to talk about Act 22. Then we get into social media. These are your Facebook pages, your websites, Instagram accounts, whatever you're using to get the word out to the public about what your department is doing. Absolutely nothing wrong with using social media. Social media is a good thing. You just need to be aware that if you are generating records through social media, chances are they fall within the public domain. The nice thing is that because they are already out there in the public domain, when you receive a right to know request, say I want a copy of your post for this particular incident or whatever, you can simply point them back to your social media page. You can say, yes, that's a public record. That's on our website or that's on our Facebook page. Here's the address for that page. And that's it. You're done. There's a portion of the right to know law that allows you to respond in that manner. Okay. And then the same conditions apply for deleted posts and so forth. If you still have access to those deleted posts, which many websites and Facebook allows you to do that, technically you're still in possession of those posts and you would need to provide them in response to a right to know request, provided they're considered public records. Okay, Act 22, like I described earlier, dash cam, body cam footage, as well as security cameras. Now, Act 22 is interesting in that it defines a police department, or I should technically say a law enforcement agency, as any entity employing a licensed or certified law enforcement officer. Okay, now interestingly, that could be a school district. It could be, for instance, Amtrak. Okay, the definition of a law enforcement agency under Act 22 is much broader than you would typically define a law enforcement agency. Okay, but Act 22 basically took access to video footage out from under the right to know law. The Office of Open Records has no jurisdiction over Act 22, but we get a lot of questions about it, so I just want to touch on it here since this is law enforcement centric. Under Act 22, if I want video camera footage, let's say it's a body cam, okay, I have to request it within 60 days from when that footage was generated. After 60 days, I can no longer request it. Or if I do, it can be denied. Now, the police department has 30 days in which to respond. The police department can charge whatever reasonable fees they deem appropriate. So under the right to know law, you can't charge for labor. Under Act 22, you can. Okay, you can charge an hourly rate that it would take us to go through this footage and make a copy for you. Also, any other reasonable fees that you think you want to tack on, you can. And if you deny access to the video footage, the person, when they appeal, it doesn't come to the Office of Open Records. Like I said, we have no jurisdiction. They appeal directly to the courts. So if you're a local law enforcement agency, they would have to go to your county court of common pleas. And with that, they have to pay the court filing fees under Act 22. And I got to tell you right now, there are very few county courts and common pleas judges who even know what Act 22 is. So we've had instances of people turning around and filing appeals with the courts, and the court turns around and says, "What's this? We have no idea what's going on here." So this is kind of uncharted territory, but you need to be aware of the distinction between the right to know law and Act 22. It's video footage, and it comes down to who is in control, who is in possession of the footage that determines whether Act 22 applies or not. Okay, but I think that's a good start for you. A good source, if you do have questions on Act 22, now is the Pennsylvania State Police. I think they've got a page on their website that gets into greater detail about it. And if you have questions, I think they have some subject matter experts that you can reach out to at this point who can get you steered in the right direction. Okay, we're now coming up on the second hurdle. And let me get a drink of coffee here real quick. Okay. We have to answer the question, is it a public record? Remember the first one, is it a record? Now we have to say, is it a public record? Well, what's the distinction? And there's a three-part test that we have to go through where we have to answer some questions. And the first one is, do any exemptions apply? And if so, are we going to invoke them? Okay, what the heck is an exemption? We go to the right to know law, section 708B. In there is listed 30 exemptions. An exemption basically is a definition of a record that the department can withhold if they want to. Okay, notice how I worded that. Can if they want to. There is discretion. The right to know law doesn't say you must withhold records. The right to know law says you can withhold records if one of these exemptions apply. Now, I mentioned 30, okay, covers an incredibly broad spectrum of records that, you know, when you look at these definitions, it's like, well, yeah, I would never release that into the public domain. Health records, any disciplinary records that we might have on an employee, any record that might put a person in harm's way. There's one in there that specifically mentions police officers and their home addresses. We would never give out the home address of a police officer or the identity of someone working undercover. Okay, so you look at these things, and there are three exemptions that particularly apply to police departments that we're going to talk about here, and I think it's the next slide. All right, so we take a look at these exemptions. We take a look at what the person is requesting. Do any of these records that the person's requesting fall into one of the exemptions? And if they do, are we going to invoke the exemption because we have discretion here? But then we come up to the second question where we have to answer, are there any federal or state statutes or a judge's order that make these records non-public? It's also mentioned in the right to know law, section 306. Okay, well, what do you mean other state statutes, other federal laws? In Pennsylvania, there's one that law enforcement needs to be aware of, and I've mentioned it. It's CREA, the Criminal History Records Information Act. Okay, and this is a law in Pennsylvania that defines a body of records that law enforcement typically is in possession of, they touch. That CREA says these records cannot be shared outside of any certified law enforcement agency. And the definition of a law enforcement agency is different under CREA. It's much narrower than Act 22. Okay. Under CREA, a law enforcement agency is a law enforcement agency. Okay. It's basically police departments, district attorneys, in certain instances, prisons, and so forth. A school board or a school district would certainly not be a police department or a law enforcement agency as defined under CREA. Okay, so under CREA, you also have a much broader universe of records than the right to know law exemptions cover. I'll give you a quick example. Under the right to know law, you've got the exemption, section 708B16, which covers criminal investigatory records. And again, I'm going to talk about that next slide. Okay. Well, I look at that exemption, there's no mention of intelligence information. Okay. So let's say our department is keeping a file on suspected gang activity within the township. All right. Well, if I were to file a right to know request for a copy of those records, there's nothing in the right to know law that prevents me from getting it. However, I would look to CREA And CREA says investigatory material is confidential. So remember, I have to meet the burden to show that a record is not public. So in my response, in my denial letter, rather than focusing on an exemption of the right to know law, I would refer to CREA as the legal basis because it is a state statute that says these records are confidential. So I would show these records that you're requesting are intelligence records as defined by CREA, and under the confidentiality provisions of CREA, we are not permitted to give them out. And I think it's important to emphasize, under the right to know law, you have discretion. Under CREA, you do not. If you give out a confidential record under CREA, you are now subject to sanctions, okay? And your department could find itself in hot water. A good source for further information on CREA is the Pennsylvania Office of Attorney General. Go to their website and do a quick search, and they actually have a handbook, a CREA handbook, which I highly recommend. Very useful, gets into much greater detail in explaining the law. Okay, and then, if there are other statutes, for instance, let's say someone requests health records for a specific officer in your department. Well, you go to the federal statutes and there's an alphabet soup of statutes that say health records cannot be given out. Now, it's also included in the right to know law, but you can, for instance, you can refer to the Family Medical Leave Act, FMLA. You can refer to HIPAA. You can refer to ADA, the Americans with Disabilities Act. All laws that say employee health records are confidential. You don't give them out, okay? So you can use those as the legal basis for meeting your burden to deny access to these confidential records, okay? And then we come up to the third question that needs answered. Are these records protected by privilege? This is referring to attorney-client privilege. Anytime there's communication between an attorney and their client of a sensitive nature, it's protected by attorney-client privilege. So here we're talking about solicitors and, senior management within the department or the elected officials, whatever. Any emails, any communication that can be documented that is of a sensitive nature is protected by attorney-client privilege and will not be released into the public domain. It's referred to in Section 305 of the Right to Know law, as well as in Pennsylvania, attorney-client privilege is documented under the rules of evidence. It's confidential. It is not released outside of that attorney-client relationship, okay? It's not subject to access under the Right to Know law. And if you have any questions, if there's any doubt, I recommend simply going to your solicitor and saying, hey, would attorney-client privilege apply in this case? And they would provide you with the appropriate guidance. If the requester disagrees with the denial, they have the right to appeal. And then one of our appeals officers will sort it out as to whether it's considered public or not. Okay, I promised we'd talk about these 3 exemptions. Of the 30, these are the 3 that law enforcement should be concerned about, okay? The first one is the most common, 708B16. It covers criminal investigatory records, so that if you have records related to a criminal investigation that either is occurring or has occurred, you can withhold them based on the language in this exemption. It doesn't have to be an active investigation, okay? It could be a 30-year-old cold case, signed, sealed, delivered, conviction, prison, whatever, okay? It doesn't matter. It can be withheld. Now, it does not include, however, what's considered blotter or incident logs, okay? And a blotter, some departments know what I'm talking about. Some, they're saying, what the heck's a blotter? Well, a blotter is like a shift diary, where in general terms, it's saying we dispatched an officer at 3:06 a.m. to an address down on 3rd Street to investigate a noise complaint. Okay, very general in its terms as to what occurred on a particular shift. All right, that is considered public, and it's specifically designated as public under the right to know law. Now, incident reports, okay, this is something a little different. There is a court case out of the Pennsylvania Commonwealth Court where Judge McCulloch said or wrote that police incident reports are inherently investigatory. Therefore, the B-16 exemption applies. A department can withhold an yeah, they pay me to speak. A police department can withhold an incident report, okay? Thus, incident reports are not considered public records. Okay, let me repeat that. Police incident reports are not considered public records. Okay, now that opens up a whole can of worms here. Because the right to know law is discretionary, you can withhold incident reports. But because it is discretionary, you can also release incident reports if you deem so. But because they're not public records, the fee schedule, which we're going to talk about here in a minute, does not apply. The fee schedule only applies to public records. So if a police incident report is not a public record, but you're releasing it because of the discretion afforded you under the right to know law, you can charge any reasonable fee you deem appropriate for a police incident report. And you can redact, whatever you believe is necessary. And many departments will do that. They'll have two versions of an incident report. One internal, that includes the investigatory information, and one for external use that's released to the media so that, they can become aware of, what was going on downtown last night at 3 a.m. with all the lights and sirens. Okay, so that's how this particular exemption works. Then we come up to the next exemption, which is 708B16, non-criminal investigatory records. Okay, well, what would a police department investigate that's not criminal in nature? It depends on your department. Two examples I'll give you. One is a suicide. Okay, the officers come in and it's apparent from everything at the scene that there was no criminal activity involved with this person taking their own life. Okay, there's, just given the way the scene is laid out, there's a note, et cetera, et cetera. Someone submits a right to know request. I'd like to see a copy of the note. Well, yeah, I mean, it's probably not appropriate for them to be able to see this given the circumstances. It may be upsetting to the family. Okay, so you're not going to release the note. So the officers, when they receive the right to know request, the arrow could claim that this was part of a non-criminal investigation. Thus, we are withholding the note as a record of that investigation. Okay, and this can cover a broad spectrum of activities that a department may be involved with. Let's say you're a very small municipality. There's no codes enforcement officer, but there is a police officer. Okay, so someone calls in with a complaint about the condition of their neighbor's yard. The grass hasn't been cut. There's trash everywhere. Guess who gets to go out and investigate? Well, it's the police officer. So they go out and check out the yard. Yes, it's a mess. We should do something about it, but there's no criminal activity taking place here. Thus, it is a non-criminal investigation because the guy who owns the yard now is going to turn around, file a right to know request. I want to know who complained. Well, under Section 708B17, it actually says that complainants, the identity of complainants is confidential. Okay, so you can withhold those names so that the police officer doesn't get caught in the middle of a neighborhood dispute. All right, so yeah, this comes in handy for police departments, a non-criminal investigation. All those records can be withheld. Then you have the third one, which 708B18 applies to emergency dispatch, typically at your county 911 centers. Any recordings of the calls that are made, whether by telephone or the radio communications between the 911 center and other, well, usually it's the police officers, whether it be, you know, in the vehicle, their portables, other county centers. It also would include localized dispatch if you still have that. All of those are protected by 708B18, so that occasionally someone will file a right to know request. I'd like a copy of the recording of the phone call that was made. They're not going to get it under 708B18. And there's other laws. I think it's let me think, Act 30 of 2016 it is. I'd have to look it up. But that says that these records are confidential and that 911 centers are prohibited from releasing a lot of information. Okay, so then you're thinking, well, wait a minute. We've all heard, you know, on TV and radio, those phone calls that people make into the 911 center of, you know, crime taking place or whatever. Well, under the right to know law in this provision, the emergency management administrator does have the discretion to release these recordings if it's in the public interest to do so. Okay, but under right to know law, they're under no other obligation to do so. Okay, appeals. Like I said earlier, appeals are a little different under the right to know law when it comes to law enforcement. Most appeals will come to the Office of Open Records unless the department has used 708B16, the criminal investigatory exemption, as their legal basis for denying access to the records. Then, if you've done that, the appeal goes to the county district attorney, and they will have like a deputy or assistant DA assigned as the appeals officer for the county. Within 15 business days, the person files the appeal with that appropriate appeals officer, and they decide whether or not the department is correct or not in denying access to those records. All other appeals come to the Office of Open Records. Okay, promised I was going to talk about costs. On the Open Records website, there's the fee schedule. Okay, and just to give you the quick 411 here, essentially it's up to 25 cents a page, 8.5 by 11 or 8.5 by 14, single-sided, black and white. Okay, if it's an electronic record, let's say it's an email, Word document, Excel spreadsheet, whatever. Okay, there's no charge for electronic records. Now, you're not under any obligation to scan in hard copy records to make them electronic, okay? If you don't have them electronic, you don't have to make them electronic. But there is no charge for electronic records that already exist. Everything else is actual costs, okay, like postage, if you are mailing out hard copy records. There is no cost for labor. You cannot charge an hourly rate under the right to know law. You can't charge like a set fee that for every right to know request that we're going to respond to, we're going to tack on an extra $10. You can't do that under the right to know law. You must follow the fee schedule as posted on our website. Any other legislated charges take precedent, and I use accident reports as an example here. This is where you have another law that attaches a fee to a record that you're giving out to the public. Okay. Accident reports are a good example because the Pennsylvania Motor Vehicle Code specifically says that agencies can charge $15 for an accident report. So that means somebody files a right to know request for a copy of an accident report, you can defer to the Motor Vehicle Code and the $15 charge, and that supersedes the fee schedule from the right to know law. Okay, so you can charge the higher of the two fees because you find that fee schedule in the Motor Vehicle Code. And this would apply to any other laws where you can find an actual fee for providing an otherwise public record. Question has popped up here. What about charging for electronic records that had to be printed for redaction? Okay, you're getting into the weeds here, but it is an excellent question. If you have an electronic record, but you have to do a manual redaction, meaning you print it out, take out your Sharpie or white out, and black out the sensitive piece of information like a social security number, and then you have to scan it back in to produce a redacted electronic record, you can charge for that piece of paper that you had to print out. But two things. First is that if you have the Adobe Office suite, you can electronically redact without any problem, okay? And it's actually more secure. All right, so if you have the Adobe Office suite, that's what you should be doing because you're not printing anything out, there's no charge. But let's say you don't have it, so you have to do the manual redaction. First, you should reach out to the requester to let them know that there's gonna be a fee because of the manual redactions that are taking place. And ask them before you do any work, are you willing to pay this fee? Many times they are not. And if so, well, then they're essentially withdrawing their request. If they are, great. Then you just proceed with the manual redaction. Everybody's happy and you move on. Okay, good question. Really good question. Okay, you guys are on the ball today. Okay, so right on time, actually a little bit over, but not a whole lot. We are at the end of the presentation. If you have any further questions, now's a good time to get them in. If we end the presentation and suddenly, something comes up, gosh, I wish I would have asked that, send us an email, okay? It'll go to the administrative staff. They're more than happy to answer your questions. Now, this last slide, it's talking about additional resources. First thing is the website that I've been talking about. Okay, I'm just going to say it. This is the best government website you will ever find. It is updated 6 days a week. New decisions that come out, both from our office and from the courts. There are guides. We happen to have a law enforcement guide on there that kind of compresses everything I've talked about here this morning, but just for law enforcement that you can print out for free. Okay, guides for citizens, guides for agencies. A final determination, those are the decisions that our office renders. They are legally binding. They carry the weight of law. They can be presented before higher level courts and must be considered as precedent. Okay, there's like 30,000 of them that we've issued in the 13 years our office has been in business. They're all in a searchable database. You can search on your department. You can search on your municipality. You can put your name in and see whether it's ever come up. Okay, random text strings. I want to search about body cams. Okay, so you type in body cams, those decisions come up. There's an open records officer guidebook, 78 pages. If you happen to be a right to know officer and you're not really sure what you're doing, number one, feel free to reach out to our office. Number two, check out our website. Number three, print out this guidebook and it will help you a great deal. Okay. And then training opportunities, that's on the website as well. Okay, it doesn't look like we have any more questions in the queue, so I'm going to sign off, but I want to thank you for your participation here this afternoon. It's been a good session. You guys had some good questions and kept me on my toes here. But thank you. Enjoy the nice weather that we're going to have for the next couple days. Law enforcement, stay safe out there, okay? And I hope to see you at the next webinar. But have a great time, folks, and we're signing off.